Good afternoon, everybody. My name is Chris Justice, and I am here once again to hopefully answer as many questions as I can within the time allowed. So, if you do have a question regarding your employment, something happened during the course of your employment, maybe you're wondering about something before it starts or after it's ended, as I say, get your questions in, and I'll do my best to answer as many as I can. But before those questions come in, I did have a few things I wanted to talk about off the top of the show. So this time around, I had a particular case come across my desk. It involved a woman who had been working at a company for a few years, and out of nowhere, she was given a performance improvement plan, a PIP is known as, regarding some apparent concerns that the company had with her performance, with the duties and responsibilities that she was tasked with. And that said, though, until she got this PIP, this performance improvement plan, her understanding, her perception of how things was going at the workplace was completely fine. From her view, everything she was doing was great. She was, in fact, exceeding expectations from her standpoint. So when she got this PIP, obviously it took her by surprise out of nowhere. She's called into a meeting. During the meeting, the company basically goes through this PIP. It was roughly about 5 pages long, and as I mentioned, it kind of listed a number of alleged concerns that the company had with this woman's performance. And the company was telling this woman as well at the same time that she had 3 months to do better, to improve her performance, or else, and then there was a threat of potential termination. So again, it came out of the complete blue for her. She had great reviews beforehand. She'd been at the company for 3 or 4 years. And so she was just generally confused and upset by what was going on, this PIP that she was given. So she contacted me. From her perspective, it seemed really far-fetched as far as what her employer was saying. She took a lot of issue with the criticisms and concerns that were noted in the performance improvement plan itself. She mentioned to me that a lot of the things that were in the plan were basically the employer nitpicking about some very minor sort of nonsense issues. And furthermore, because she was so surprised, the reason why she was surprised by the PIP is because she had no knowledge, no notice of the employer having any apparent concerns with her employment before she got the PIP. So she basically told her employer before she contacted me that she never even had a chance to know about the issues before she was put on this PIP. And had she been aware of these things, had she been notified of this stuff, at the very least, she could have responded and addressed the situation at that point. So I said the same thing to her about asking for notice being given before, why notice hadn't been given before. And I told her as well, like everybody, is that if you get a PIP and you disagree with what's in the PIP, whether or not you're given an opportunity to respond beforehand or not, you want to address the issues in the PIP itself, the inaccuracies. So sometimes when it comes to criticisms, it could be a criticism that's just simply not true. There's no basis for it. So it's just flat out inaccurate, and you would want to highlight that and bring that to the attention of the company. Other times, concerns that are put in there are either very minor, and again, it seems like nitpicking from the company, or they're taken out of context. So maybe it's not entirely untrue, but they're omitting a lot of other factors at play that might explain why something in your case happened or didn't happen as far as your performance. So as I say, I told her, make sure you make your voice known. You can be professional, but at the same time, express your disappointment with them as far as how they didn't give you any advance notice, how basically they just jumped right to a performance improvement plan. And so these were a lot of the things that when I contacted her employer, I brought up as far as there being no notice, as far as there being a number of issues with the PIP itself, inaccuracies. And eventually, HR actually came to me at the company and said that they agreed. HR at the company notified me that they looked into the situation further and realized that there were a number of things on that performance improvement plan that were not true, or that had not been proven to be true by this employee's manager. And so actually what happened in this case was the manager, the one who issued the performance improvement plan with all the criticisms and comments in there, that person ended up getting disciplined, number one, for basically putting together a faulty or an inaccurate performance improvement plan, but also for not giving the employee any heads up notice before issuing the plan itself. So there was discipline given in that context. And ultimately, the PIP itself was removed from the employee's record. HR had stated to me that it's not something that they were going to rely upon for the reasons that I've noted, the deficiencies that I've noted. And basically, things eventually went back to how they were. It was still a point of frustration for this woman, but it was removed. And obviously going forward, there's probably going to be more of a focus on making sure from the company's end that these things are done correctly. So the PIP was removed. The manager who issued the PIP was disciplined. And at the moment, the woman in question is doing much better, and she's able to go back to doing her job without having any of the stuff sort of operating in the background. But I do think it brings about an important lesson, which is, again, you don't want to be silent. You don't want to, not respond in the face of a PIP that's so clearly wrong. If you do go down that path and you don't respond, that's going to be seen as you basically accepting the PIP, acknowledging in one way or another that the concerns may be legitimate or are legitimate. And when it's not the case, you definitely don't want that to be, because later on, if they try to rely on that PIP to let you go, your silence is going to be, in many cases, held against you. And then you're not going to have as many options on your way out as far as getting more severance is concerned, or there's going to be some greater difficulty, I think, in getting what you're owed when the time comes, if that does happen. So you want to voice your concern, you want to speak up, because otherwise it's not going to look good generally for you. So this, as I say, this woman I spoke to did just that. I also did that on her behalf after I communicated with the company, and it ended up working out in her favor and having that removed. So that was the key part of this particular matter. And I think the most important lesson is you do need to preserve your rights by stating what's the case, stating what actually happened or didn't happen. And you cannot be silent in the face of an unfair or improper performance improvement plan. So for those that are in that position, definitely be mindful of that. If you do have any questions, if you're ever in a situation like that and you want to respond, or you're thinking about responding to the employer, but maybe you don't know the exact way to go about doing it, then absolutely you can give us a call at our firm. We can set up a consultation, and we can at least go through how to best paper your trail, how to best communicate the things to say, so that if they ever do try to rely on that later, you've done what you needed to do and you've preserved your rights and put yourself on a much better footing. There were a few things I wanted to talk about as well. That was the one case that came across my desk the other day I wanted to chat about. I will get into maybe some of the other stuff I wanted to touch on at the top, but I do have some questions in from you guys. So I do want to get around to answering some of those. So the first one comes from Gail on YouTube, who's saying that they asked for medical accommodation from their doctor, submit to the insurance as much information as required, but the insurance still denied the accommodation. What would be my next step? So this could be a two-parter, because you've got, on the one hand, the employer, the company you work for, that you're looking for an accommodation from. And then you also have the insurance holder, the insurance company, who it seems like have denied the accommodation. So I think the first question would be to understand what medical support, what medical evidence or information you've submitted. Because normally if you've submitted medical information or notes that speak to an accommodation you need in the workplace, generally speaking, the employer has to accommodate. They have a duty to accommodate. Unless the accommodation is so extreme, is so major that it would cause serious issues within the organization, even if there's some inconvenience or burden, the employer still has to accommodate, assuming you can do, most or all of your job in accordance with whatever the doctor's saying. So there could be a failure to accommodate on the employer side, which could actually trigger a termination and entitle you to your severance, as well as potentially human rights damages, since there's an overlap of medical or health related issues at play here. Unfortunately, employers sometimes don't want to have people back into the office or the workplace until they are 100% and that no accommodations needed. But that's not the duty that they're under. That's not the obligation they have when they're considering things like this. So the employer itself could be in hot water either way as far as just failing to accommodate. But the insurer, the insurance company, they too could be in some hot water as well. And so I mentioned the first thing is to understand the medical information you've submitted. The second thing would be to understand or try to get an understanding of why the insurer, the insurance company, denied the accommodation. Are they denying it on the basis that they don't believe there's sufficient medical information supporting the request? Have they denied it on the basis that they believe the accommodation, while legitimate, is too significant to be made from the employer's side? So it may come down to some of the specific reasonings or rationale with that. But this also brings up another issue where people are trying to get short-term or long-term disability benefits, and they will apply or make an application for those benefits through the insurance company. The insurance company can approve it, which in that case is good. Obviously, you'll get your benefits, but a lot of times the insurance company will deny someone's request for disability-related benefits, again, maybe based on the medical information or some other factor. But unfortunately, a lot of times they are denying these claims unfairly or unjustly so. And so in a lot of cases, there could not only be a case that you have against your employer for not accommodating you in the face of this medical support, but there could also be a case against the insurance company for improperly denying you access to benefits, taking the wrong approach or making the wrong conclusion when it came to their decision to either deny or to accept the benefits. And we at our firm also deal with these insurance companies. We deal with getting people the full short-term or long-term disability that they're owed, because a lot of times, as I say, these insurance companies will rubber stamp things and just deny you, thinking or hoping that that's going to be the end of it. But you should know that there is an ability for someone to commence a legal case or an action against the insurer for the denial of benefits, just as there is a case or an action that someone can bring towards the company for failing to accommodate. So I think, Gail, because there's probably some information that's either sensitive or otherwise that you'll need to provide so we can get a full context of your case, I would definitely recommend you give us a call, set up a consultation, and we can at least advise you on all the different avenues that you have before there's maybe any significant more back and forth of communication between you and the company or between you and the insurance company. But thank you for your question. It does, I think, apply to a lot of people out there. I've got another question in from Jamie, who's saying that they've started a new job, but they received a significantly better offer, which I'm assuming is from a different employer, so someone other than the job you just started with. They also say that their employment contract requires 4 weeks of notice. If they resign immediately or give less notice, what legal risks are they taking? So it is true, there are oftentimes in a contract you sign, it will contain some language around resignation. Most often you'll see maybe 2 weeks of notice. That's typically the minimum. But depending on the position, how senior it is, maybe how much time it would take to replace someone in that position, if it's a more senior role, sometimes you'll see in a contract a greater amount of notice of resignation than just 2 weeks. So in Jamie's case, it seems to be 4 weeks. So even though the job was just started, I think the risk is that if you resign immediately without any notice and just leave, like say the following day, or leave within a week or two, instead of 4 weeks, the employer may highlight the fact that you signed this contract, that the contract has a certain amount of notice for resignation required. And so if you give, let's say, 2 out of the 4 weeks of notice required under the contract, and you don't give the employer the other 2 weeks and you just leave after that point, there is the potential, not to say it happens all that often, but there is the potential for the employer to pursue something against you for what's, I think, generally known as wrongful resignation. It's not something that comes up a lot. Even when somebody does give less notice than is required under the contract, a lot of employers don't find that it's worth it at the end of the day to have to potentially commence a lawsuit or action against someone just to recover maybe 2 or 3 weeks of pay. So I think for practical reasons, it probably doesn't come up that much, but it is still technically possible. What I would say is it's probably best to have a conversation with your current employer, let them know of the situation, because I think that'll help provide some context as far as why you may need to leave sooner rather than later. You can also propose something to them and say, look, I understand the contract says I need to give 4 weeks. Are you okay if 2 weeks from today is my last day? And try to get them to consent to it or agree to a lower amount of notice, which could, of course, amend the contract you signed. And also will give you a bit of peace of mind to know that if they do agree, you're not having to worry after those 2 weeks are up of them possibly coming after you, even if it is a relatively low chance. But those, I'd say in general, are the risks. So to err on the side of caution, that's why I suggest having a conversation and maybe letting the employer know. For the most part, I find in my experience, the employer is open to discussing it and coming to a compromise. But if there are any greater amounts of pushback from the employer, then you may just have to proceed one way or another, knowing the potential risk. But I think that's the general answer to your question, Jamie. So thanks for that. It doesn't come up that often, but it does come up enough where I think people need to know either way. I have another question in from Brenda, who's saying that their employer, their company has started telling staff that they're not allowed to leave during their lunch break in case they're needed for something. And Brenda is asking if that's allowed. Brenda is also saying they use their lunch to run errands for their family. So generally speaking, under the law, you're, of course, depending on how many hours you work in a given day, entitled to a lunch break. Normally, or also, again, depending on the hours, you're going to be entitled to a couple of other breaks during the day, shorter than the lunch, but a couple of other breaks. And at least as far as those bare minimum aspects are concerned under the law, you're fully entitled to those. There can be a situation where an employer may give you a greater amount of time for your lunch or a greater number of breaks. I mean, that's all well and good, but there still is a bottom line in terms of the time off during these breaks. And so an employer can't basically ask you to compromise those bare minimums, because then it would run risk of violating employment standards. So I think to ask somebody to stick around during their lunch break is one thing. And if that person wants to help out during their lunch break and maybe get another break added on top, if they have to put in certain amount of work, maybe something could be negotiated there. But as far as I'm aware, there's nothing where an employer can say, we require you to do this, and if you don't do it, maybe you're at risk of being let go, because then you're basically getting retaliation for something that you're saying is your bare minimum right under the law. So I think if push comes to shove, it could pose a problem for the company if they're going to really insist on that. And in your case, Brenda, if they do, I think definitely you should give us a call so we can kind of step in and nip it in the bud. I've got another question in from Snuggles, who's saying that they're being bullied and undermined in their position as a retail department manager, and they're overlooked for a position that they're qualified for. So good questions. Second part of that, being overlooked for a position you qualify for, while frustrating, I'm sure it can be for people in that kind of a situation. There's not going to be any inherent right to a position, even though you may be qualified for it. You'd have to have some kind of a contract or something in writing in place from the employer that may basically state that you have that position or you can get that position, or something in writing that confirms you can get that, or some guarantee or assurance from the company that you will get that position. But I think if you don't have something in that sort of ballpark along those lines, it's more of a frustration point than it is an illegality, not something illegal. But as far as the first part of your question, being bullied and undermined in your position, that can definitely be a potential issue from a legal standpoint. Of course, we've got in general anti-harassment laws, anti-harassment policy requirements that are put in place in companies. So they've got to have something there in place if there is someone that's being bullied or harassed. Normally, if you're being bullied or harassed in the job or during your work hours, depending on what you define as bullying and harassment, I would definitely suggest putting together a formal complaint, putting it to HR so at least they can investigate, so at least they're made, aware of the issue without sort of bringing that to the forefront. Unfortunately, a lot of companies may just take the position that you haven't raised it with them. They didn't understand it was a concern. They would have looked into it had you brought it up. So I think that's the starting point, is to raise these issues. And hopefully that kind of stuff can be nipped in the bud as well. But if someone has raised the issues or presented a complaint and the company just tries to brush it under the rug, or maybe they do an investigation, but it's not a fully fledged or objective, neutral investigation, then that's where employers run the risk of getting into some hot water. They've got to make sure that the workplace is healthy and safe, and that includes being free of bullying and harassment. And if they don't ensure that that's achieved by ignoring your claim or brushing things under the rug, then basically they're promoting, I guess what I would say, a toxic work environment against their obligations to provide something the opposite of that. So then that can create that toxicity. And in a lot of cases, that can force people out of their position, and they leave out of frustration or because, it's just a case of the straw that broke the camel's back. So I think if you bring it to their attention, depending on how they respond, you may actually have a case against them to leave, to go after the company for severance, potentially other things as well, just given there's an overlap with the harassment and bullying issue. So in some cases, companies are punished with additional punitive damages for bad faith if they've acted in a particularly egregious manner. I've got just a follow-up comment here from Snuggles. I see it says that they're investigating the matter. The store manager and Snuggles have to wait to see what happens, but they're also known for covering up for store managers because right now they're trying to move me from to another store without finishing their investigation. Yeah, I think you need the conclusion of the investigation for sure, because that might pinpoint what happens as far as whether any move happens. And also, the outcome of the investigation may show that they did cover some things up. They may show that the company didn't do certain things during the investigation that they should have, and are covering up or backing somebody who has engaged in harassing behavior, which again is a big issue, I think, for them, and something companies in general need to be very careful with. So it might be helpful to get a sense, if you can, as far as the timeline of the investigation, how long it may take, but they are supposed to give you a summary of the outcome, sort of what happened, whether any action was taken as far as any of the problematic people that are involved. They don't have to give you a full-blown investigative report, but they do need to give certain information and details, so you definitely want to follow up there. But again, depending on how things unfold, you may be in a situation where you have, much more of a leg to stand on as far as going after them for certain amounts of money, which may be in your interest if you don't want to be there anymore. Or you could potentially go in a different direction, and maybe you just want to keep the job, but you need to get rid of a particular toxic element within the job. And if that's removed or somehow that's fixed, maybe you're open to continuing working in a different way. Whatever your goal is or your end point is here, it's something that we can definitely try to help out with and try to guide you along. But thank you for the question. I do appreciate it. I've got another question in from Vanessa, who was saying that they were laid off due to restructuring, but their role is now being posted again with a different title. And Vanessa is asking whether they can challenge the termination. So Of course, you can challenge the termination in a sense if you believe the reason for the termination is not what's being stated. A lot of times, or often enough, companies may say someone's being let go due to restructuring, but there could be ulterior motives. There could be some discriminatory reason for why they're doing it, and they're just hiding behind the idea of restructuring. I think that if that's something that's there, then absolutely you can, challenge the basis for the termination and suggest those types of things. Obviously, if you can prove that to be the case or convince potentially a court that that's the case, then you would be entitled to punitive damages or damages of that nature just based on the bad faith that I was kind of talking about before. Now, as far as challenging the fact that you were terminated, in most cases, you're not going to be able to reverse that decision unless you work for a federally regulated employer. Sometimes in those cases, there is a chance to get reinstated if the reason isn't valid enough. But if you're a non-unionized, let's say provincially regulated employee, or you work for a provincially regulated employer, there's not going to be much you can do to reverse the decision of the termination. All you can generally do is make sure that you're getting a fair severance package. And obviously I mentioned the bad faith, so that's a separate issue. You can potentially pursue that. But the first issue is normally making sure, did I get enough severance from the company? Have they lowballed me? Have they shortchanged me? Are they trying to rely on something I signed beforehand to lower the amount they pay me? A contract maybe I signed when I was hired. These would all be things that we would look at our firm in a consultation to figure out whether and to what extent they have any leg to stand on. But I would at the very least get in touch with us, Vanessa, to ensure that you're being offered or given a fair severance package, again, at the very least. And then during that call, maybe we can figure out and flesh out other aspects of maybe why this happened or something that might be going on in the background to pursue that avenue as well. So there could be, potentially a lot on the line in both of those aspects. So definitely give us a shout. And, as I say, we can let you know either way what your options are, and moving forward, you can decide. I've got another question in from Thor. This will be the last one just before I end it for the afternoon. Thor is saying they developed a severe reaction from the COVID-19 vaccine. They've now been, considered disabled. They're saying the company has refused to accommodate the disability and forced me onto LTD. There's more, but I don't want to overwhelm. So for sure, give us a shout if there's more. Maybe something that needs to be fleshed out in a sort of a fulsome consultation. So that's absolutely number one. Number two, though, if you are disabled, you have the backing and the support from your treatment providers, family doctor, whoever. That's, again, usually the starting point to make sure that you've got that support, that backing from the experts. And then as far as the company's decision to accommodate your disability, it's going to come down to the reasons why. A lot of times they improperly refuse to accommodate. So there could be a failure to accommodate issue, just like the other person I spoke about earlier on in the show. That could open up a can of worms for the company. Forcing you to go on LTD. I mean, again, it kind of depends on what led them to forcing you to go on that disability. Hopefully there's no issues with the insurance company, the LTD carrier. Again, sometimes those things are denied as well, and the insurance company doesn't believe you qualify for a disability, so you might have a potential claim against them. But again, you mentioned there's a lot more here, so probably better to schedule a more fulsome consult and then kind of go through it and at least just make sure, again, you understand what your options are, and hopefully we can guide you down the best path to take. But with that said, everyone, again, thanks for your questions. Apologies for those that I didn't get around to answering, but definitely tune in again. We host these things all the time. So for those that I didn't get around to answering questions for, you see down below there, this Wednesday, September 17th, you'll have Sefton here. He'll do a great job, I know, answering questions. So tune in then, get your questions in at that point. But as far as today's concerned, that's my time. So thanks, everyone, again, for attending. Do hope you have a great rest of your Monday. All the best. Take care. Bye for now.